Good afternoon, New Zealand, Indonesia and the world. This is Karen Harding, lawyer for the 26 fishing crew who are the subject of an appeal at the Court of Appeal tomorrow, the 12th of October 2016, and today is the 11th of October 2016. I've prepared a one-page summary of the argument for the second respondents, being the fishermen. This is as follows. We submit that His Honour Justice Davison's decision of the 18th of December 2015 was correct, and that the appeal of the Sajo Oyang Corporation should be dismissed. To deny the innocent crew members their wages, which can be fully paid out from a forfeited sistership after the crew worked in such abject conditions, is repugnant to justice and will result in a manifest injustice. This would damage New Zealand's international reputation and adversely affect commerce at sea, which requires a trusted source to pay crew wages. The Ministry has failed to consider the context of the situation provided for in the section of 256 round brackets 1 of the Fisheries Act 1996 when considering interest in unpaid wages, claims over quotation marks other forfeit property, end quote. A forfeited sistership owned by the employer can be other forfeit property in our submission, causing no offence to the purpose of the section. The crew have an interest in unpaid wages without prior commencement of in-room proceedings over Oyang 75. The crew are impoverished persons recruited to work on work permits from Third World. Accordingly, the relief process needs to be simple and inexpensive. To require multi-jurisdictional litigation complicates relief procedures under Section 256 that is not intended. This renders it unusable and denies crew a remedy when their vessel is lost. It is impossible for crew to make an in-room claim before obtaining legal representation when a vessel worked on is lost, has left the jurisdiction, or when the forfeiture of vessels occurs quickly. The Ministry has failed to consider all public policy considerations. The intent and purpose of the Act, which is the Fisheries Act 1996 under Section 256, is to protect crew on foreign vessels from economic exploitation. There is a public interest in ensuring the minimum wage is paid to crew as provided for under Section 103, subsection 5 of the Fisheries Act 1996. The position adopted by the Ministry and the appellant, the Sajo Oyang Corporation, over Oyang 75, accordingly would lead to an unjust windfall to them. It would reward the appellant for violating New Zealand law, and it would permit the Ministry to profit from the misery of vulnerable persons employed on the appellant's, the Sajo Oyang Corporation's vessels between the period of December 2007 and October 2011 before the forfeiture date who have been denied the minimum wage. Here are our submissions as to why the appeal should be declined and judgment should be in favour of the second respondents. Thank you.